Judicial interference in the protection of human life, a perspective from the United States. Hi, I'm William Saunders, and I'm pleased to be able to participate in this conference, though I'm sorry it is only remotely. A conference on a very important topic. Indeed, there is no topic that is more important than this, the protection of human life in the prenatal phase. Indeed, there can be no more important topic at all, because any system of rights that is built upon the denial of the first right, the very foundation stone of human rights, which is the right to life, is built upon a network of falsehoods about the human person and about the nature of society. Such a system, in its very roots, denies the possibility of achieving the common good. I must also add, I'm glad that this conference is being organized in Warsaw, because I have felt for a long time that the intellectual resistance to certain anti-life trends coming from Western Europe must begin in Poland. Furthermore, I am glad to present a paper on the topic the conference organizers requested, which is an analysis of Supreme Court of the United States rulings in their social and bioethical context. I have three essential points to make and three conclusions to draw. The first point is this: to understand the experience of the United States, one must recognize that abortion was imposed upon the country by our Supreme Court. I use the word imposed intentionally to indicate that it was an all but ultra vires manner in which the Supreme Court did so. I will demonstrate this point by a brief review of America's legal and political system. As most of you probably know, the United States is governed by a written constitution. The U.S. Constitution, at least to American eyes, is an old and venerable document. A few days ago, 5th anniversary. Unlike national constitutions in some European countries, for example, it has remained relatively unchanged since it was adopted, having been amended only 27 times during those 225 years. Nonetheless, for the Constitution to win ratification initially by the then sovereign states in 1787, a series of amendments were necessary. Called the Bill of Rights, the first 10 amendments set forth the rights that citizens of the states wished to make certain they were not losing by agreeing to a national compact. The Bill of Rights protected many rights that are now commonly protected in constitutional democracies, such as freedom of press, freedom of speech, freedom of religion. Furthermore, you should be aware that after the American Civil War, a series of amendments were adopted. Called the Civil War Amendments, these amendments, the 13th, the 14th, and the 15th, were aimed at securing the full and equal rights of Black Americans. I can assure you that nowhere, neither in the original text of the Constitution, nor in the Bill of Rights, nor in the Civil War Amendments, nor in any other amendment, does the word abortion appear. Further, the U.S. system of government is one of what we Americans call federalism. I suspect Europeans would use the word subsidiarity. Whichever term is used, the principle is the same. That government power is not concentrated, is not to be concentrated at the national level. Rather, government power is diffuse through a system of state, local, and national governments. It has been the historical assumption in the United States that all matters need not be solved at the national level. Most of the work of governing, most of the resolution of issues characteristic of a democracy, is left to the individual states and to the more local level. The American system is also characterized by a formal doctrine called separation of powers between the Congress or the Parliament, the President or the Executive, and the judiciary. This is true on both the national and state levels in the United States. On the national level, as set forth in Article 3 of our Constitution, the role of the Supreme Court is quite limited. In all but 2 cases, the jurisdiction of the Supreme Court is, and I'm quoting the Constitution, appellate under such regulations as Congress shall make. So, in other words, Congress has the express power to limit the influence of the Supreme Court by restricting the kinds and numbers of cases it reviews. Thus, to summarize, one would reasonably expect the question whether there should be a right to abortion, as well as the extent of such a right, to be decided by the people through their elected representatives at the state level. And in fact, that is precisely how the issue of abortion was being addressed before 1973. Efforts were being made in some states to create non-punishable categories of abortion or to liberalize laws against abortion in a even more general way. But these efforts were vigorously resisted. The political battles were heated, and the tide surged back and forth in particular state legislatures, depending on particular circumstances. In other words, democracy was working. But all that changed in 1973. In 2 cases decided the same day, the U.S. Supreme Court announced that the Constitution gave a right to abortion. Under the American system, national laws are, quoting the Supreme Court, quoting the Constitution, the supreme law of the land. So national laws as the supreme law of the land displace any inconsistent state laws. So the effect of these decisions by the Supreme Court was that in these 2 linked decisions, the Democratic efforts to deal with abortion in all 50 states were rendered null and void. All restrictions were swept away. America was now a nation of abortion on demand. And let me be clear what that means. It means that a woman can obtain an abortion at any time for any reason. Now, I imagine those attending the conference who are not Americans find this shocking. And it is shocking. Let me explain a little more about how it came about. The 14th Amendment to the Constitution, one of the Civil War amendments I mentioned before, says, among other things, that a state may not deprive any, quoting the Constitution, may not deprive any person of life, liberty, or property without due process of law. The court held that under this provision that the fetus was not a person for purposes of constitutional protection under the 14th Amendment. And it rejected arguments based upon a state's obligation to protect people within its jurisdiction. That was in Roe. In Roe's companion case, called Doe v. Bolton, the Supreme Court extended this new abortion right throughout all 9 months of pregnancy. It did so through what is referred to as the health exception. What does that mean? What it means is that the court defined the term health of the woman to include any factor relevant to the well-being of the woman, whether physical, emotional, psychological, familial, or age. In other words, it defined it very broadly, any factor on any of these bases. And as subsequent Supreme Court cases have in fact demonstrated, this expansive definition of health means that abortion simply cannot be precluded if the woman wants it. In the most important subsequent Supreme Court case called Planned Parenthood v. Casey, which was decided 20 years later, 19 years later, in 1992, the Supreme Court affirmed that there was a right to abortion. This time it no longer relied upon an implied privacy right as it had in Roe and Doe. In other words, in those cases, it used an implied privacy right to be broad enough to cover abortion. It didn't do that in Planned Parenthood v. Casey. It still found a right to abortion, but it placed it squarely under the term liberty in the 14th Amendment, which I read to you above, and defined liberty in a very expansive way with a focus on personal liberty. In fact, I'll read this to you, their definition. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. So it used that very broad definition of the term liberty in the 14th Amendment to define the right to abortion. Importantly, for what we're talking about, since the decision did not change or limit the meaning of the health exception, the situation remained, and in fact remains to this day, essentially the same as when Roe and Doe were decided. Abortion is available at any time for any reason. Only 3 or 4 other nations in the world have as expansive an abortion right as the United States does. Though the court in Casey called upon those who were protesting this permissive abortion regime that the court had created, though it called upon them to end their protests and accept the court's resolution of the issue, they have not done so. For example, in January of 2013, a few months from now, the March for Life, which protests those very Supreme Court decisions establishing a right to abortion and which numbers hundreds of thousands of persons, will take place in Washington, D.C., as it has every year since Roe and Doe were decided in 1973. That is, for 40 consecutive years. Abortion remains at the center of American politics and elections, including this year's presidential election. My first essential point, then, to repeat, is that abortion was imposed upon the United States despite the absence of authorizing language in our fundamental legal document, the Constitution, and despite our system of federalism and of separated powers, which should have logically entailed that the issue was left to the political process for resolution in the 50 individual states. Now, I said I had 3 points and 3 lessons. So the first lesson I draw from this, and which I submit to the conference to consider, is this. In order to protect life, legal protection must be as explicit as possible. Otherwise, modern courts, enlivened by a rights-creating mentality, will likely find a way to create a right against life. The fundamental legal political documents of a country should preclude this in express terms and should expressly limit the power of the courts. My second essential point is that the effects of these jurisprudential decisions by the Supreme Court, denying the legal protection to a whole class of human beings, could not be limited in any sense to the abortion context. Rather, they infected all of society. Now, Roe has been defended or explained as being about the right of a woman to control her body. This is implicit in the court's holding, and I'll quote the court from Roe. We conclude the right to personal privacy includes the abortion decision. Understood on this basis, it was claimed that Roe did not have consequences beyond the abortion context. In other situations, i.e. those situations where the woman's right to control her body was not at issue, Roe would not apply. So it was claimed. However, the intense public debate about stem cell research in the United States over the past decade demonstrates this claim is false. In that debate, though the issue had nothing to do with a woman's body, those supporting human embryonic stem cell research denied that the embryo was a human being. They denied that simple, straightforward scientific fact. The task of these advocates was made easier in two important ways by Roe and Doe, one obvious way and one more subtle. The obvious way in which Roe and Doe prepared the ground for these kinds of non-arguments by the advocates of embryonic stem cell research was that since the Supreme Court had decided embryos were not persons under the 14th Amendment, it seemed to follow, to most people, most citizens, that they were different from other human beings in important ways and that they could be appropriately subjected to lethal violence in any circumstance, while other human beings could not be. There's no arbitrary killing of other human beings allowed. But the Supreme Court seemed to teach us that human beings before birth were a different kind of human being who could appropriately be subjected to lethal violence. And if that was true, people concluded they can be subject to lethal violence in the context of the woman's body or in the context of a research laboratory and a petri dish. Still, the more subtle and indeed I think the deeper way that Roe and Doe infected and affected the stem cell debate is this. It taught the American people that scientific facts can be ignored for policy reasons. The court in Roe understood that a crucial issue was when life began. However, the court concluded, quoting the court, it need not resolve the difficult question of when life begins. The court concluded that. Why did it conclude that? Because the court found that there was a divergence among certain sources, among religious, philosophical, historical, and legal sources on this point of when life begins. However, amazingly, the court did not consider what is really the only relevant discipline, that of embryology. All the other considerations really were beyond the point. Embryology has always been clear that from the first moment of its life, the embryo is a human being. And for a long time, it has been clear that the first moment occurs at fertilization. Had the court admitted this simple scientific fact, it would have been forced squarely to confront questions both of the constitutional personhood of that human being and of a state's obligation to protect the lives of people within its own jurisdiction. At a minimum, the court could not have pretended that since the basic question of the humanity of the embryo or fetus was unsettled, it could proceed to what we call a judicial balancing of the different interests involved to come up with times when embryos could be destroyed for certain reasons, etc. And so this is my second essential point. Roe could not be limited to the abortion context. The effects of Roe and Doe could not be limited to the abortion context, but had a deep and important effect on thinking about other issues. Thus, the second lesson I draw from this second point, and which I would submit to the conference to consider, is this. Failure to protect human life in one area of law will lead to failure elsewhere. Life must either be protected everywhere or it is at risk everywhere. My third and final point is that while the American context is illustrative, it is not sui generis. It is not unique. That is to say, Europeans and Poles face the same risks. I have been involved as an attorney in various cases in the European Court of Human Rights. Decisions by that court in Tysiak v. Poland and ABC versus Ireland in R&R v. Poland convinced me that the threat of an activist judiciary is not limited to the United States. The threat may be less intense in Europe at present, but I see the European Court of Human Rights trying to open a wedge in national laws, despite the margin of appreciation which nations are to enjoy, in order to advance anti-life positions. So in conclusion, then, my third lesson I draw, and which I would offer for your consideration, is this. Poles and other Europeans should take heed, learn from, America's bad example and guard against repeating our mistakes. Thank you very much, and I wish you a very successful conference.